USFSPA Decoded, Dividing Military Retirement Benefits in a Utah Court. Before we begin, a quick note. This video provides general legal information about military retirement and divorce. It is not legal advice, and watching this video does not create an attorney-client relationship. The script for this video was prepared by Utah divorce attorney Eric K. Johnson of Utah Family Law, LC. I am not an attorney, and I cannot give legal advice. Every divorce case is different, and the way the law applies to a particular situation depends on the specific facts involved. Military retirement in divorce is surrounded by myths. You will often hear that the benefits must be divided 50-50, that the marriage must overlap 10 years of military service, or that disability payments count just like retirement. None of those statements are accurate. Here's the problem. Military retirement sits at an intersection of federal law and state divorce law. If you misunderstand how those systems interact, the retirement award you think you secured may later prove unenforceable or far less valuable than expected. Governing federal statute is the Uniformed Services Former Spouses Protection Act, often called USFSPA. What that law actually does is simple but frequently misunderstood. It authorizes state courts, including Utah courts, to treat a service member's disposable retired pay as marital property and divide it during a divorce. Notice what it does not do. It does not create an automatic right to half of the pension. Utah courts still apply equitable distribution principles. That means the marital portion of the retirement benefit is divided in a manner that the court considers fair. Often, that results in something close to equal, but not always. Now, consider the jurisdiction trap. Federal law requires something more than ordinary personal jurisdiction before a state court can divide military retired pay. The service member must either reside in the state for reasons other than military assignment, be domiciled there, or consent to the court's authority. If none of those conditions exist, a court may dissolve the marriage and divide other property, but cannot divide the military pension. Orders issued without that jurisdictional basis may later be rejected or set aside. Another common misunderstanding involves the so-called 10-year rule. Many people believe a pension cannot be divided unless the marriage lasted 10 years during military service. That is incorrect. The 10-year rule applies only to direct payment through the Defense, Finance, and Accounting Service, commonly called DFAS. If the marriage overlapped military service for at least 10 years, DFAS can send the former spouse's share directly to them. If it did not, the pension can still be divided. The difference is that the retiree must personally transmit the payments. Disability waivers introduce another complication. Military retirees may waive a portion of retirement pay in order to receive tax-free disability compensation. Under federal law, that waived amount is no longer disposable retired pay, and if it is not disposable retired pay, it cannot be divided as marital property. Supreme Court decisions have confirmed that state courts cannot require reimbursement when such waivers reduce a former spouse's share. This means the value of a retirement award can change after divorce. Finally, drafting matters. Vague language, missing jurisdictional findings, or orders that fail to comply with DFAS requirements can make an award difficult or impossible to enforce. In military divorces, precision is not optional. Federal law determines what can be divided. State law determines how it is divided. Understanding that interaction is essential to protecting the value of military retirement in divorce.